This is our Level 3 Hearing Board Committee agenda. We will call the meeting to order this May 4th, 2026 at 5 p.m. We will establish the board committee members in attendance. We have Courtney Daughter Bruce, Garrett Wilson, and myself, Christy Schmidt. Following is open session, visitor comments and testimonials, which we have had no one sign up for today. For closed session, pursuant to Texas Code Section 551.071, attorney consultation regarding legal issues related to the Level 3 parent grievance process. The next item on the agenda is to consider the Level 3 student-parent complaint appeal brought by Caleb Hudson, raising concerns about what he feels is unequal or inappropriate actions by Bernie ISD staff regarding his rights as a parent. The Level 3 appeal will be heard in open session as Mr. Hudson has requested the hearing be in open session. Prior to starting the grievance appeal, the board, pursuant to Section Code 551.071 of the Texas Government Code, will consult with its legal counsel in closed session concerning the grievance appeal process. After the legal briefing is concluded, we will return to open session to conduct the grievance. The time now is 5:01 p.m. don't want it. All right, we are reconvening from closed here. It is now 5:12 p.m. and the board is now in open session. We are here to consider the Level 3 appeal from Mr. Caleb Hudson, referred to as parent for this hearing. Texas Education Code Chapter 26 allows for a board subcommittee or panel to hear a parent grievance, and we are following that practice tonight. Accordingly, we have 3 board members hearing this grievance, and those 3 board members will decide the outcome of the grievance. That decision will be a final decision of the Boerne ISD School Board regarding this grievance. The following board members are present: Courtney Daughter Bruce, Garrett Wilson, and I'm Christy Schmidt, the board president. The school board's attorney, Rob Decker, is also present to advise the panel with respect to this matter. Board members, will each of you state whether you are able to serve as an impartial member of this panel and can make a decision based solely upon information and documentation presented at this grievance presentation? Any member not able to act in such a manner may say so and ask to be excused. I am an impartial member and can serve on this committee.
I'm impartial, can serve on this committee.
I'm impartial and can serve on this committee.
A recording of this hearing is being made. To provide the most accurate record possible, please avoid speaking when others are talking so that the recording will reflect the proceedings accurately. The recording of what is presented here today, the board packet that was shared with the parent prior to the board meeting, together with the district's policy F&G legal and F&G local, are the agenda and minutes for the meeting. For this meeting, once approved, will constitute the official record of this grievance. For the record, will the parent and then followed by members of the administration team presenting in this hearing please state your name to identify your voice for the recording?
Caleb Hudson.
Can you please come up to the mic?
Caleb Hudson.
Thank you.
Dr. John O'Hare, Chief Administration Officer for the district.
Jill Rhodes Pruin, Chief Human Resources Officer for the district.
Thank you. These are the procedures for this hearing. First, the parent will make his presentation. When finished, the administration will be permitted to make a reply. The parent and the administration each will be allowed 10 minutes to complete their respective presentations. This is not a formal evidentiary hearing. There will be no questioning or cross-examining of others, meaning the parties will not ask questions directly to one another or to the board members. Within the specified time, the parent will make his presentation of what he wants the board to consider. The administration then will be given an opportunity to respond. Board members may ask questions of the parties after both presentations are completed. Board members, your questions should seek clarification about the grievance facts presented or remedies sought. Board members, I request that you refrain from interrupting or asking your questions until both sides have finished their presentations so that we can maintain an accurate record of the time used by each party. When all board member questions have been addressed, each side, beginning with the parent, will be allowed 2 minutes to provide a rebuttal or closing statement. Once those statements have been made, the board will excuse ourselves and deliberate concerning what has been presented, and then return to open session to take possible action on the appeal. Are there any questions regarding the conduct of the grievance appeal hearings? So we will start our timer. In the back there, technology, we have a timer of 10 minutes. And parent, you may now go ahead and head to the microphone to proceed with your presentation, and we'll begin the time whenever you start.
Okay, thank you. Good evening, trustees. My name is Caleb Hudson. I am the father and joint managing conservator of my children, and the governing court order does not require me to obtain the other parent's permission to participate in their education or school activities. For the record, I requested that trustee Rich Senna and any trustee with a direct or indirect relationship to individuals identified in Appendix F or Kimberly Hudson consider whether recusal was appropriate to preserve neutrality. The district's decision to grant that request and adjust board participation accordingly reflects recognition that neutrality concerns were present and required action. That same principle remains central here. not just in participation, but in whether the board is being asked to evaluate a complete and neutral record. Under Texas law and the governing decree, joint managing conservators retain independent and equal rights unless a court order expressly limits those rights. That principle is the foundation of this grievance. At the center of this record is a simple issue. The restrictions I encountered did not come from the decree. They arose from one parent's input, which the district chose to act on. The clearest example is when I was told I needed mutual agreement to attend a parent-teacher conference. That requirement does not exist in the decree. It is not required under Texas law, and the district's own HR guidance later confirmed that. Yet the record was never clearly corrected. That is not neutrality. That is a condition imposed outside of the decree. The district now acknowledges that both parents retain independent rights. That is correct, which raises a straightforward question. If the district knows the correct standard, why was it not applied consistently? The issue is not intent. It is whether the district's actions are supported by a reliable and consistent process. That concern is not limited to past events. It exists in the record before you. The board packet exceeds 3,000 pages, and at initial review, it omitted a material document. My written rebuttal addressing the district's positions on the public information requests. That document was only included after I requested it. That raises a fundamental concern about completeness. But it goes further. The district's April 15th correspondence appears early in the materials. My response, submitted the same day, appears only at the very end. These documents directly respond to each other. Separating them creates a structure where the district's conclusions are encountered first, framing the narrative before the full record is considered. That is not just incomplete, it is structurally imbalanced. And that structure directly affects how the record is evaluated. In addition, factual questions submitted to clarify the record, contained in Appendix C, remain unanswered. Those questions were provided so that the district could explain who made decisions, what policies were relied upon, and what records support those actions. To date, those answers do not exist. So even if documents are physically present, the process itself remains incomplete. The board is being asked to review not just an incomplete record, but an incomplete process. This is reinforced by the public information requests. The district represented that responsive records existed, sought to withhold them, and when required to support those claims, produced nothing. The Attorney General ordered release. The current position is that all records were already produced and no additional records exist. Those positions cannot all be true at the same time. A process that cannot produce a verifiable record cannot support the conclusions it is used to justify. And ultimately, the board is being asked to affirm conclusions drawn from a process that was not completed and a record that cannot be fully verified. The Level 2 response concludes that no wrongdoing occurred and that the investigation was objective and conducted in accordance with policy. But those conclusions depend entirely on the completeness and reliability of the record and process used to reach them. If the record is incomplete, if material questions remain unanswered, and if the process itself was not fully carried out, then those conclusions cannot be independently validated. And if those conclusions cannot be independently validated, then they cannot be responsibly affirmed. That places the board in a clear position. Either affirm a record that is incomplete and structurally imbalanced, or direct the district to complete the record so that its conclusions can be evaluated on a reliable and neutral foundation. There is not a third option that preserves both the integrity of the process and the validity of the conclusion. So the issue before the board is not disagreement. It is whether a conclusion can stand on an incomplete and unreliable record. For that reason, I respectfully ask the board to confirm that a joint managing conservator cannot be required to obtain the other parent's permission absent a court order. To ensure parental access is implemented neutrally and independently, and to ensure grievance processes are conducted with full neutrality from the outset. My goal is simple, that Bernie ISD applies the law and governing decree consistently and neutrally to both parents. I respectfully request that this statement be entered into the grievance record, and I decline to answer any questions. Thank you.
Thank you, Mr. Hudson. The administration may now proceed with a reply.
Good evening, members of the board. This complaint began with an October 14, 2025 parent conference scheduled by Mrs. Hudson and a request from Mr. Hudson to be physically present at that meeting. The campus staff were aware that Mrs. Hudson did not want to be in the same room with Mr. Hudson, and they began to offer Mr. Hudson alternatives, such as scheduling his own parent conference. Mr. Hudson has expressed, both in conversation and in email correspondence, that he firmly believes he has the right to physical joint attendance at a parent conference scheduled by Mrs. Hudson. The administration does not agree. Under Texas Family Code 153.073, Mr. Hudson's orders, both parents, as joint managing conservators, have equal rights to receive educational information, consult with school officials, and attend school activities. However, the statute does not require that both parents be included in the same meeting or be invited to the same conference. It simply guarantees that each parent has the right to communicate with school personnel and obtain the same information. The school's obligation, reinforced in BISD Board Policy FL, is to ensure that both parents have equal access to information, not to require joint attendance. The Texas Education Code, Chapter 26, gives parents rights to information and involvement in their child's education, but it does not mandate that both parents attend the same meetings. Specifically, Section 26.008A states the parents are entitled to access written records about their child's education. This law ensures access to information, not physical presence at a meeting. The Family Education Rights and Privacy Act, or FERPA, gives both parents the right to inspect and review educational records, request corrections, and be informed about their child's educational progress. FERPA, like Texas law, does not guarantee the right to be present at any school meeting or any event, and only governs access to records and information. The divorce decree provided to the campus names both parents as joint managing conservators, but it does not provide any specific direction to the school regarding joint attendance at a parent conference. In fact, Bernie ISD is not mentioned in the decree at all. The divorce decree provides direction from the court to the joint managing conservators. For example, on pages 6 and 8, it directs the joint managing conservators to collaborate with one another on educational decisions for their children. Since the disagreement about the conference, Mr. Hudson has since brought up previous events, meetings, and communications that he alleges demonstrate a pattern of his rights as a joint managing conservator being infringed. There's a January 2025 communication where he expressed concerns that he was not receiving evaluation and consent form information from the school that were sent to Mrs. Hudson. There's a January 29, 2025 parent conference with campus staff and Mr. Hudson where an SRO was called into the room. The administration recognizes Mr. Hudson's role as a joint managing conservator. In response to the January 2025 concerns, the campus staff at that time added to the records for his students in the Skyward Student Information System that states, when the school notifies one parent, be sure to notify both parents. All staff can see this when they log into the student's Skyward account. Additionally, Mr. Hudson was provided direction to create his own Skyward account for parent access. While the campus was not required to take these steps, these measures were extra efforts put in place to support Mr. Hudson's requests. Page 37 of Mr. Hudson's divorce decree already requires both joint conservators to immediately notify the other parent, verbally or in writing, of any matter related to the child's education status, including social activities, grades, homework, field trips, disciplinary slips, progress notes, teacher conferences, and the like. In the Level 1 response, the administration reiterated its support for Mr. Hudson's role as a joint managing conservator and its commitment to provide access to any educational records for his students. The response granted 2 of Mr. Hudson's 4 requested remedies and partially granted another. The only requested remedies that were not granted were his request to have physical access to any and all meetings, conferences that Kimberly Hudson requested, and his request to be notified of any communication that Mrs. Hudson had with the campus. The administration communicated that it would continue to work with Mr. Hudson to provide options for parent conferences where one parent did not want to be physically present in the room with the other, such as separate conferences, conferences via Zoom, etc. Mr. Hudson maintained that he had the right to be physically present at a parent conference scheduled by Mrs. Hudson, and he filed an appeal. In the Level 1 remand response, the administration reiterated its support for Mr. Hudson's role as a joint managing conservator and its commitment to provide access to any educational records for his students. The administration granted 7 of Mr. Hudson's 10 requested remedies and partially granted another. The requested remedies that were denied were his request to have physical access to any and all meetings and conferences that Kimberly Hudson requested, and his request to provide corrective guidance to ensure future compliance with parental rights standards. In the Level 2 response, the administration reiterated its support for Mr. Hudson's role as a joint managing conservator and its commitment to provide access to any educational records for his students. The administration granted 7 of Mr. Hudson's now 30 requested remedies and partially granted 2 others. The requested remedies that were denied at Level 2 included that the district agree that offering separate conferences was not a viable solution, his request to restrict Mrs. Hudson's physical access to any and all Bernion ISD campuses, his request to have the school resource officer stand outside Mrs. Hudson's classroom when she is performing her duties as a substitute teacher, his request to be the sole decision maker regarding all of his kids, and his request not to allow Mrs. Hudson to pick up his kids from school. To touch on an area that Mr. Hudson has brought up, public information requests he made. The district began receiving Public Information Act requests from Mr. Hudson on October 11th. Between October 11th, 2025 and February 25, 2026, the district received a total of 19 public information requests. A list of these requests has been included in the record. Due to the volume of the requests submitted by Mr. Hudson, as well as supplemental emails, the district engaged legal counsel, Walsh Gallegos, on October 24th, 2025, to assist in responding to these requests. Given the nature of the information sought, legal counsel submitted 7 requests for rulings to the Attorney General to determine whether the requested information would qualify for withholding exemption. Many of Mr. Hudson's requests were outside the scope of regularly maintained records and contained lists of questions to which he requested responses. The Public Information Act does not require a governmental body to create new information, to do legal research, or to answer questions. The Act only requires the production of responsive documents. Because Mr. Hudson requested information that required database and email server queries from the Technology Department, including specific searches on both district and personal email addresses and numerous keywords, a cost estimate was determined utilizing the Attorney General calculation guidelines. As a result of Mr. Hudson's numerous requests, employees have spent over 100 hours researching and compiling data related to Mr. Hudson's requests. No student information has been withheld from Mr. Hudson. Only files containing personal or privileged information have been withheld per the Attorney General. Mr. Hudson mentioned process. Mr. Hudson has been afforded every step of Board Policy FNG. He has received a Level 1 hearing, a Level 1 remand hearing, a Level 2 hearing, and now a Level 3 hearing. He has received a written response to his Level 1 hearing. He has received a written response to his Level 1 remand hearing. He has received a written response to his Level 2 hearing. This is the response that the board's policy requires. It does not require us to respond to every single question that is submitted. In summary, the administration is supportive of Mr. Hudson's role as a joint managing conservator. This support has been repeatedly demonstrated in the campus and district staff's multiple efforts to engage Mr. Hudson in dialogue and response to his communication needs. The campus and the district have produced educational records for Mr. Hudson upon every request, and the campus has taken the extra step to use the Skyward system to direct staff to reach out to both parents when sending communications. We have granted the remedies we believe are reasonable and appropriate. We are not able to grant Mr. Hudson's remedies which we deem unreasonable. The administration respectfully requests that the board committee uphold the Level 2 decision. Thank you.
Thank you, Dr. O'Hare. Mr. Hudson, for the record, did you refuse to answer questions? Yes. So at this time, any board members who wish may now question only the administration party, because Mr. Hudson has refused to answer questions. If you need any clarification of fact, issue, or request for relief.
I had a couple questions here. Dr. O'Hare or Mrs. Bruin, whoever's more applicable. Can y'all describe when we go through a divorce decree, is that fairly common for us to get divorce decrees and go through them and have to interpret them basically and come to conclusions on what's in them?
Sure, I'll talk to you about our process. I'm on that, sir. So we from time to time, campuses receive divorce decrees from parents. They're usually submitted to the campus administration or the campus registrar. Typically, if they have any questions about them, if they're not familiar with reviewing them, they'll send them to the Office of Administrative Services for review. Those documents can be pretty lengthy. We look for two very specific things in those decrees. We look for who has been granted educational rights in the decree, and then we look at custody. The information in the decree with respect to educational rights will tell us who can receive information. In this case, both parties are joint managing conservators, and they both have the right to receive educational information and make educational decisions. And then we look for custody arrangements so we can help support who's supposed to pick up the kids and get the kids to school each day.
Perfect. And who is it you said that they send those to for guidance if they need it?
They send those to me, to my office.
Oh, okay. So they do have some help with that. I mean, because those are fairly complex documents. So they,
Yes, sir. And if
yeah.
I encounter anything that is out of the ordinary for me, I'll send it to our attorneys over to Walsh Gallegos for review.
Okay. That was my question. Is if yeah, perfect. Okay.
Would there be any benefits to the child or children of Mr. Hudson to have had one parent conference with both parents present versus having two with each parent individually?
The goal there is to get them access to the same information, right? The administration, the campus's standpoint is that they can get access to the same information about the students by having two separate conferences, just like they could being in the same conference. So no, we didn't see any added benefit to having them both physically present in the same conference at the same time.
Thanks.
Ms. Jill Rhodes Bruin or Dr. O'Hare either. Mr. Hudson is telling us that the record is not complete due to missing information and key documents from various public information requests. Your understanding is that all responsive documents have been submitted, including the PIAs for the Level 3 appeal. Can you please clear this up for us?
So the district has produced all documents responsive to Mr. Hudson's requests in accordance with the Attorney General's Public Information Act guidelines. This production was coordinated with the district's legal counsel, as Dr. O'Hare shared, and our legal counsel has confirmed that there are no responsive documents that have been withheld. Any documents not produced fall within the recognized exceptions, and those include attorney-client privilege or other documents the Attorney General has approved for withholding. In terms of the discrepancy, it likely arises from a difference in understanding regarding the scope of the request or the nature of the records maintained by the district. And I'll give you an example. Mr. Hudson submitted requests for email records using multiple search criteria, such as references to parent-teacher conferences and several employees. These searches initially identified hundreds of potential responsive documents. However, upon a review, the district limited the production to the documents that met all of Mr. Hudson's specific search criteria. The documents that were excluded from production generally contained information pertaining to other students or other employees which were not appropriate to disclose to Mr. Hudson. Mr. Hudson, following that request, Mr. Hudson subsequently requested an index of all of the excluded documents. However, the Public Information Act does not require that a government body create additional information or answer questions. Rather, it requires that we only produce existing or responsive documents. Therefore, we provided the responsive documents through our legal counsel.
Thank you.
Dr. O'Hare, is it fair to say that if there's two different meetings, one with one guardian and then another with another guardian, is the second meeting that takes place on the same content, does the second guardian having that meeting later on have equal rights in the decision-making and the access to information and decision-making as the first guardian in the first meeting? Do you understand the question?
I do.
Yeah.
Sure. So when you look at the decree that's been provided to us, right, both parties, both joint managing conservators, have the independent right to make educational decisions after conferring with the other party. So if we hold conference one, and in conference one, at the end of the conference, first joint managing conservator says, I want my kid to go into special education testing. okay, they've made an educational decision and they have the right to do that, and the school will proceed accordingly. Then in the second conference, if we have a parent conference with a second parent and they say, I do not want my kid to have to go into special education center, they also have independent decision-making rights. The district then has to stop and act accordingly. And those two parents can go back and forth making different decisions. And in the interim, in the time between when we hear from them, we would adjust accordingly to those two parents, right? The idea when you look at the divorce decree is it directs them to confer with one another before making those decisions, right? And as a school district and as a campus, we can assume that that's happening, right? Especially when they provide us a divorce decree where the family court says they're directed to do so, right? So in the first conference, we would assume when parent X says, I want my kid to be tested for special education testing, that they have conferred per their decree with the other joint managing conservator.
Yeah, so I mean, if my wife went up and unenrolled our kids, for instance, and didn't tell me, they would get unenrolled. And then if I went back a week later and enrolled them back, you wouldn't call or anything, you would just pull them back. Is that what I'm hearing? If I came up a week later and re-enrolled them?
Yes. Yes, if we've had that happen before, where parents come up and unenrolled their students, and then one of the other parents has come back in a short version time later and re-enrolled the students in school. We've actually had a case where that's happened a couple different times. They've gone back and forth until they got on the same page about it.
Just for the record, in the divorce decree 10.4a, it says it is ordered that Mr. and Ms. Hudson have the duty of informing the other conservator of the children in a timely manner. Therefore, it seems like it would be their jobs to inform each other of the children in a timely manner.
Yeah. Is that, for instance, what's our normal procedure as far as if my wife called up and, wanted to have a meeting with one of the teachers about one of our kids, anything educational wise?
Sure. If a parent called up and wanted to schedule a meeting with one of the teachers of one of the kids, we would take the request from the parent. We would reach out to the teacher and put them in contact directly so they could schedule a time to get together either in person or via Zoom or via phone in order to have the conference.
If my wife did that and called up there and did that, would y'all call me first and notify me that it was happening, or make sure?
No, that's not our typical process. Whether they're joint managing conservators or whether they're parents that are still married, we assume collaboration between the parents outside of school, right? And we're required to grant the request of a singular parent as long as they both have educational rights. So if one parent comes to us and requests a meeting, we're going to schedule the meeting.
Yeah, I guess that's where I struggle with, when you're trying to make rules for all 11,000 kids, it's, it's tough to
We've tried,
notified,
like that statement the campus made, but they put on Skyward that we will, hey, teachers and everybody, when we're making an effort to reach out to parents, like when we're talking about teacher conferences, or we're gonna make an effort for this student to contact both parents. That's our effort because Mr. Hudson made us aware of the issues he was having communicated with Mrs. Hudson. That's the school's extra effort to get out there and say, hey, we're gonna make an extra effort to get information when we're communicating. The supplemental issues that he's had is when we're not initiating the communication. It's when Mrs. Hudson is reaching out to the campus, he's wanting the campus to reach out to him after that happens. And you're correct, that's not something that we can sustain. That's not a reasonable request.
I have a question real quick. There was an incident that happened on the playground when I was reading through. And what steps does a district take to notify parents of an emergency situation or behavior? Maybe in that particular case or in general cases, how does this work when a divorce decree has been submitted and trying to appeal to both parents? Can you explain that situation?
Sure, and there's no one singular process for when a divorce decree has been submitted. When we receive a decree, we review the decree, and our response is in accordance with what's in there, right? Again, what rights do the parents have, and then what's the custodial situation, right? So if there's an emergency, it really depends. Like, let's say the kid gets sent to the nurse's office because the kid got hurt, right? The parent's going to call the first parent on the list, the first parent they can get a hold of, and inform them what's happened with the kid. they're not necessarily going to call the second parent when they do that. Their charge is to make parental notification. They'll contact that first parent, and then again, they're going to assume that the parents are going to corroborate and talk to one another, or the joint managing conservators are going to corroborate and talk to one another offline. In this specific instance that you're referencing, I believe what actually happened there was Mrs. Hudson sent a message to the teacher to let her know that her student had been slapped on the playground by another student. More of a, hey, teacher, I just want to let you know this happened. I've talked to my student, and I've let him know that if it happens again, I expect him to inform a teacher. That, I believe, is the message, and then Mr. Hudson got that later when he filled out his public information requests. He contends that the school at that point should have called him to let him know. But again, it's not a communication from the school to Mrs. Hudson. That was a communication from Mrs. Hudson to the school, and per her divorce decree, she's required to share that information with Mr. Hudson.
Okay.
That's not the school's responsibility there.
Thank you for clarifying that.
Yes, ma'am.
Yeah, thinking about, I'm glad you brought up Skyward. So whenever we're registering our kids on Skyward, there's a parent contact of the first parent contact, and then there's a second parent contact, and then there's an emergency contact, correct?
Yes, ma'am.
If you have any other questions, we'll finish out questions, and then we'll have their 2 minutes.
I just wanted it to be on the record that Bernie ISD made sure that both parents were entered in Skyward as the contact person. So if you contact one, you contact the other. Is that standard practice in the district, or how is that usually handled?
We typically, when we open up student registration, right about this time of year, right, we ask every parent to give them the opportunity to relook at their contact information, make sure it's accurate and current. Each parent that has access to Skyward has the ability to fill out a registration form and give us information. And then once we have that information, we use that to develop our mailing lists, right? So if you've got an email address from parent 1 and parent 2, and we send out a parent email, we pull the listserv, all the parents will get access to those emails, right? Teachers will pull their lists from Skyward too. They'll get access to those, and they'll send out teacher emails to Skyward. And so our understanding that process was working. There was a January 29th, 2025 meeting between Mr. Hudson and the campus to talk about communication. And in that meeting, he affirmed that he was getting email correspondence from the school, that he was getting email correspondence from the teacher at that point.
Is it safe to say that Mr. Hudson could schedule a meeting without his ex-wife's presence at any time? I mean, within reason, right? The teachers and everybody have jobs to do and stuff, but he has the ability to independently schedule a meeting without her consent or knowledge.
He has the ability to schedule his own meeting, yes, sir. He should, if he's following his divorce decree, then inform her of that meeting. That's what his decree requires him to do.
Okay.
Turn this on. I have a question about the counseling sessions. So how does the district support the decision-making rights of parents? And can you please explain how this relates to Mr. Hudson's complaint about his children receiving in-school counseling services? Sure.
So when it comes to decision-making rights for parents that have a decree in place, right, it depends on what's stated in the decree, right? So we review that. In this case, the decree grants both parties independent educational decision-making rights. And so that means that each party has the independent ability to make an educational decision with their child, with the caveat in the decree, after they confer with the other party, right? So if Mrs. Hudson wants to schedule counseling services, and this particular instance that I believe you're referring to is the March 2024 incident. So keep in mind that's before the current legislative law that requires us to actively seek consent for counseling services. That didn't go into effect until 25-26. So prior to 25-26, in that particular case, that Mrs. Hudson can call up and request counseling services, and we're going to schedule the student for counseling services per that parent's request because she has the right to do so. And then if Mr. Hudson disagrees with that, calls us up later and says, I don't want counseling services, then the parent will stop counseling services and work through that. The January 29th, 2025 meeting, that was kind of the crux of that meeting, was the campus administration working with Mr. Hudson and trying to provide options about psychological testing and services for the student because he made it clear that he didn't want them, but then Mrs. Hudson had asked for them, and then they believed there was an educational need for one. And they did leave that meeting stating, hey, if you don't want this done, you have the right to make that decision. We're not going to do it.
Any other questions, board, committee?
One other question is on, when we go from level 1 to 2 to 3, how normal is it, or is, I know we did it here, but is it customary to add different requests at each level of the grievance process? How's that normally done?
It's new. If you remember, in response to Senate Bill 12, Chapter 26 of the Texas Education Code added very specific guidance for local school districts' grievance policies. And the school district adopted a new FNG policy in the fall. On our previous policy that we had, no, that was not typical. Whatever you put on your form at the very beginning in your initial remedies, that is what you progress through the grievance process with. And so this year we're kind of in new territory. Mr. Hudson's been allowed to submit new documents, new requests all throughout the process because that's what the Education Code allows for and what our current FNG policy allows for.
Yeah, and that's based on Senate Bill 12.
Yes, sir.
Too. Okay.
In Mr. Hudson's case, when he reports not receiving information, what is the district's process for investigating and resolving the concern?
Sure. If any parent tells us they're not receiving information, my expectation is that the campus is going to reach out to the parent, get some more clarity on what information they're not receiving. They'll then verify their contact information in Skyward, make sure we have their email address correct and it's up to date, make sure we have their phone number correct and it's up to date. And then depending on the nature of what they tell us, work to troubleshoot that problem. In this case, the January 29th, 2025 meeting was one of the responses from the campuses to meet with Mr. Hudson and talk about his communication concerns and see what they could do to support that. And it was at that actual meeting that the campus put in place the additional direction on Skyward for the campus to reach out to both parents when making contact.
You feel like our student parent handbook reflects that statement that you just mentioned? You feel like our handbook is up to speed or up to date, if you will, on these policies that we're discussing right now?
Yes, ma'am.
Any other questions?
Doing that, sorry. I just think it's important for the record, if there is any other conversation that we want to have, Dr. O'Hare or Ms. Jill Rhodes-Pruen, on the level 1 and level 2 complaints, you granted or partially granted several of Mr. Hudson's requested remedies, and just wondering if you feel it would be necessary, just for the record, to explain why the other remedies were not granted or were only partially granted. I know we touched on that when you spoke earlier, but if there's any other need for the record to explain those again, just to reiterate for understanding.
Sure. I can run you through those real quick. So in our level 1 response, Mr. Hudson requested the specific remedy to be given acknowledgement that he would have physical access to any and all meetings and conferences, et cetera, that Kimberly Hudson requested and is notified of as it relates to his 3 kids. We denied that requested remedy and stated that the school's obligation is to ensure both parents have equal access to information and not to arrange joint attendance. The parents may collaborate with one another to arrange joint attendance should they wish to do so. He requested the remedy at level 1 for Bernie ISD to notify him in writing of any and all conferences, meetings, communications, and paperwork between Bernie ISD and Kimberly Hudson as it relates to his 3 kids. And we partially granted that. The school would provide Mr. Hudson access to any educational records for his students upon request. The campus will continue to try to be sure that all student information provided to one parent is provided to another. We get to the level 1 remand. Mr. Hudson requested to be given written acknowledgement again that he have physical access to any and all meeting conferences that Kimberly Hudson had requested and is notified of as it relates to his 3 kids. We denied that with a similar rationale that we gave in the level 1 response. Mr. Hudson also requested for Bernie ISD to notify him again in writing of any and all conferences and meetings, paperwork, and communication between Bernie ISD and Kimberly Hudson as it relates to his 3 kids. We partially granted that with the same rationale that we provided in the level 1 conference. And then he asked to provide guidance to ensure, he requested that the campus provide corrective guidance to ensure future compliance with parental rights standards. We denied that, stating that we have not identified a need for corrective guidance related to this request. The campus response to your September 18, 2025 request to physically attend a conference scheduled by Mrs. Hudson complied with all legal parental rights requirements. While the campus was working with both parents to offer alternatives with the goal of meeting the needs of both parents, Mrs. Hudson canceled the meeting weeks before it was scheduled to occur. Moving forward, the campus will continue to communicate with both parents to support their duty as joint managing conservators that is specified in their orders to inform one another of significant information concerning health, education, and welfare of their children. At level 2, Mr. Hudson requested the remedy to reverse or modify the level 1 remand decision to the extent that it treats violations as cured by the offering separate conferences or adding skyward notes after the fact. That remedy was denied. Having rationale provided was having considered the complaint at your level 2 conference, I'll uphold the decision made at the level 1 remand by Dr. John O'Hare, as I found Dr. O'Hare provided you with appropriate reasons for his decisions, and those reasons are valid. At level 2, Mr. Hudson requested that we make a clear written finding that BISD staff shall not require mutual agreement, written approval, or consent from one parent as a prerequisite for the other joint managing conservator's attendance or participation, absent a documented court order or lawful restriction. That was denied. The rationale we provided is that the school's legal obligation is to ensure that both parents have equal access to information, not to require joint attendance. The parents may collaborate with one another to arrange joint attendance should they wish to do so. The campus is prepared to offer a number of other options for parent conferences that may accommodate the need for both parents and provide both parents with access to educational records. These include recording the conference and offering a copy of the recording to both parents. For meetings that require joint parental participation in decision-making, such as IEP 504 meetings, both parents shall be included. Mr. Hudson also requested level 2 to issue explicit directives that staff not honor requests that condition one parent's access on the other parent's consent, provide identical and contemporaneous notice of conferences, meetings, and events to both joint managing conservators, and provide access without creating veto structure. That remedy was partially granted. The rationale provided was that the school will provide you with access to any educational records for your students upon your request. The school will not require Mrs. Hudson to be present in the same conference with you. It is not the role of the campus administration to mediate disputes between you and Mrs. Hudson. The school will continue to provide you an alternate means to gain information that Ms. Hudson requests about the children upon your requests, and any information that the campus district pushes out will be provided to you both. Mr. Hudson also requested that we order record cure actions to correct and prevent recurrence of non-neutral communications and unsupported narratives, including written reactions and clarifications, distributions, systems of record correction, specific non-neutral escalation, and an equal inclusion directive. That remedy was partially granted with the rationale that if evidence reflects that any statement in the record is biased, inaccurate, or unsupported, the record will be promptly corrected. In accordance with Board Policy FL Local, within 15 district business days of the record custodian's receipt of a request to amend records, the district shall notify the parents in writing of its decision on the request, and if the request is denied, of the right to a hearing. You will receive written notice outlining the correction on any related updates. As both parents retain independent rights to attend conferences, receive educational information, and consult with campus staff, the campus will honor decisions communicated by either parent consistent with applicable law and any governing courts. Mr. Hudson also requested the remedy that we direct administrative guidance or training on the following: custodial neutrality between joint managing conservators, prohibition of informal conditions inconsistent with court orders, documentation standards for any law enforcement involvement in parent-school interactions. That remedy was denied with the rationale provided that the district seeks guidance from its legal counsel regarding court orders, and campus and central office administrators implement procedures in accordance with that guidance. School districts are not party to court orders, and our role is to implement any orders we know of in the ways we believe are fair to all parties and helpful to students. If the parent has an issue with the clarity of an order, the parent must address the concern with their attorney and the court to add more specific language to their court order. Nothing presented indicates employees acted inappropriately or that a need for training exists. Training requirements for Texas school district employees are established through a combination of state laws enacted by the Texas legislature, regulations issued by the TEA and the State Board of Educator Certification, and local policies adopted by the district's Board of Trustees. The superintendent retains the sole authority to determine when and how district employees receive training. School resource officers are responsible for maintaining the safety and security of students, staff, and other stakeholders, and will intervene as necessary to ensure orderly operation of the campus. Mr. Hudson also requested the remedy that we order following training for campus officials involved in implementing parental access and conference participation decisions, professional judgment training, situational awareness training, decision-making training under stress. That remedy was denied with the rationale provided that nothing presented indicates employees acted inappropriately or that the need for training exists. Training requirements for Texas school district employees are established through a combination of state laws enacted by the Texas legislature, regulations issued by the Texas Education Agency and the State Board for Educator Certification, and local policies adopted by the district's board. The superintendent retains the sole authority to determine when and how other employees receive district training. Mr. Hudson also requested the remedy that we order the following training for employees involved in parental access determinations where an employee-parental relationships creates an appearance of favoritism at risk, conflict of interest training, preferential treatment training, and ethics training. That request remedy was denied with the rationale provided that nothing presented indicates employees acted inappropriately or that the need for training exists. Training requirements for Texas school district employees are established through a combination of state laws enacted by the state legislature, regulations issued by the TEA and the State Board of Educator Certification, and local policies adopted by the district's Board of Trustees. The superintendent retains the sole authority to determine when and how district employees receive training. Mr. Hudson also requested the remedy that we order BISD employees to cease gatekeeping one parent's lawful rights, where that parent is a joint managing conservator with zero limited rights, and there is no documented lawful restriction. That remedy was denied with the rationale provided that the school's legal obligation is to ensure that both parents have equal access to information, not to require joint attendance. It is not the role of the campus administration to mediate disputes between you and Mrs. Hudson. Mr. Hudson also requested the remedy that we provide specific answers to the following questions based on the district's draft response to his initial 12 questions dated December 7, 2025. Where the district states, Mrs. Gillette let the leadership team know that there was a parent that was possibly upset with the school about parental notification. Please identify the date and time of that communication. Please identify who specifically was included in the leadership team. Please identify the medium, and please identify what was communicated. That requested remedy was denied. With the rationale provided, the district is unable to locate any communication related to your request on this date from either Dr. O'Hare or Ms. Gillette. Mr. Hudson also requested the remedy that his request to be physically present in his kid's scheduled activities by his ex was denied by the district. Please specify what current Texas law supports the decision to deny a joint managing conservator with zero limited rights the ability to attend their child's educational activity. If there is none, please explicitly state if there is one. That remedy was denied with the rationale provided that Texas law does not require a school district to interpret or enforce the terms of a custody order. The district's role is to educate students and maintain a safe and orderly environment, not mediate or resolve disputes between parents regarding conservatorship, parenting rights, or access. The school's legal obligation is to ensure that both parents have equal access to information, not to require joint attendance. The parents may collaborate with one another to arrange joint attendance should they wish to do so. The district will not compel one parent to meet jointly with another parent. When scheduling conferences or interactions, the district will work with each parent individually, consistent with applicable law and court orders on file. Mr. Hudson also requested as a remedy, as level 2, that the district's current procedural remedy to justify separate conferences is to record and share, but the district's current position regarding another parent-teacher conference that he was not a part of on October 24th, 2024 has to date been withheld by pending AG direction. Does the district acknowledge that the potential procedural loophole with their current remedy? That requested remedy was denied with the rationale provided that the district seeks guidance from its legal counsel regarding public information requests. Based on the information requested, legal counsel made the decision to refer the request to the Attorney General, as your request included access to all communications between Kimberly Hudson and school staff, as well as visitor management records. Mr. Hudson also requested as a requested remedy and any given severity of information at the timestamp related to PIR 006-2026, the day after his son was assaulted, it is reasonable to say that the district is continuing to withhold safety information regarding his child that only his ex has been privy to. That requested remedy was denied with the response provided. There is no evidence your son was assaulted, and the district is not withholding vital safety information. On January 31, 2025, Kimberly Simmons, Cibolo Creek Elementary Assistant Principal, responded to your email titled Nathan's Incident in October, in which you state, Nathan was grabbed by the hips and the other student thrusted at him. Mrs. Simmons stated, "The teacher addressed it in class and reported it to me as soon as it happened. BISD student code of conduct was followed in addressing it with the student. There was no disciplinary action with Nathan, but I always notify the parent when something of that nature occurs." Mr. Hudson requested the remedy that if Bernie ISD maintains the remedy of separate conferences, plus record and share, how does the district justify the current and ongoing procedural gap that exposes risk and liability? That specific remedy was denied with the rationale provided that the district does not agree that the practice of conducting separate conferences and documenting and sharing relevant information creates a procedural gap or exposes the district to risk or liability. Providing separate conferences is a common and appropriate practice when parents are unable to meet jointly. This approach allows the district to ensure both parents have equal access to educational information while maintaining a safe and productive environment for staff and families. Relevant information from each conference is documented and maintained in accordance with district procedures and applicable law. Both parents retain the right to receive educational records and communicate with campus staff independently. The district's processes are designed to ensure compliance with applicable law while avoiding involvement in parental disputes. Accordingly, the district does not view this practice as creating legal exposure. Additionally, Mr. Hudson requested the remedy that will Bernie ISD honor my request to restrict my wife's physical access to any and all Bernie ISD campuses starting the date of this appeal filing. That requested remedy was denied. The district has no basis for restricting Mrs. Hudson's access to Bernie ISD campuses. Mr. Hudson requested the remedy will Bernie ISD honor my request to restrict my ex's physical access to any and all campuses where my kids are currently enrolled starting at the date of this appeal filing. That requested remedy was denied. The rationale provided the district has no basis for restricting Mrs. Hudson's access to Bernie ISD's campuses. Mr. Hudson requested the remedy my ex is currently a BISD employee and a substitute teacher and regularly works at Cibolo Creek Elementary School. When my ex-wife is working, will Bernie ISD honor my request to have the local school resource officer stand outside her classroom or office and enter her location when she asserts her lawful parents' rights? That requested remedy was denied. With the rationale provided, the district has no basis for the school resource officer intervention based on a phone call from Mr. Hudson. The remedy requested was, will Bernie ISD honor my request to be the sole decision maker regarding my kids? That requested remedy was denied. As both parents retain independent rights, the campus will honor decisions communicated by either parent consistent with all applicable law and any governing court orders. The remedy requested was, will Bernie ISD agree not to allow my ex to pick up my kids from school? That request was denied. With the rationale provided, there's nothing in the divorce decree limiting Mrs. Hudson's rights to pick up her children from school. The remedy requested was, will Bernie ISD agree to notify me about any and all safety incidents about my kids? That request was denied. With the rationale provided, all children's Skywards accounts have notifications indicating when the school notifies one parent, be sure to notify both parents. So it had already been addressed. The requested remedy was, will Bernie ISD agree to hold parent-teacher conferences with me? Will agree to only hold parent-teacher conferences with me? That request was denied with the rationale provided that the school's legal obligation is to ensure that both parents have equal access to information, not require joint attendance. Parents may collaborate with one another to arrange joint attendance should they wish to do so. The campus is prepared to offer a number of other options for parent conferences that may accommodate the needs of both parents and provide both parents with access to educational records. These include recording the conference and offering a copy of the conference to both parents. The remedy was requested that with and all these requests, will Bernie ISD agree to claim that there's no documentation to support any of this, and if anyone tries to assert their lawful parent rights by seeking transparency and clarity through the PIR process, will Bernie ISD agree to submit any and all of those requests to the Attorney General and ask to withhold that information? That requested remedy was denied with the rationale provided that the district seeks guidance from its legal counsel regarding public information requests, and the district reserves the right to submit requests for information to the Attorney General based on guidance from legal counsel. The requested remedy made at level 2 was, would Bernie ISD agree that the above results are unreasonable to implement towards other joint managing conservators with zero limited rights and zero objective evidence of wrongdoing? That requested remedy was denied with the rationale provided that this question is rhetorical. The decree that you shared does not limit either parent's rights to attend educational or school activities, meetings, nor does it require that parents meet together. A parent attending a meeting must consult with the other parent before making major decisions concerning their child's education. And that concludes the list.
Thank you.
Mr. Hudson, you now have 2 minutes to provide your last comments for the board. Once completed, administration shall have the same 2 minutes as well. You can start whenever you're ready.
Thank you. Trustees, I have an easy solution for this complicated grievance. Follow Texas law and stop searching for loopholes based on one employee parent's preferences. And for the record, my questions about restricting my ex's access was a reflection of what the record before you shows, but that it actually occurred to me. And yet the district defends those principles when it applies to their own employee. Keep in mind that even after the dual notice protocol was implemented in Skyward, there is evidence in your record where Ms. Juarez failed to notify me regarding another counseling session. And also keep in mind that I have a record of the school calling Ms. Hudson about my son's assault on October 23rd, 2024, and yet to this day I still don't have any information further about this incident, except what is limited in the grievance record. And trustees, again, it's not complicated. The district now agrees on the correct principles, that both parents have independent rights, that access should not be restricted, that communication should be provided to both parents. Those principles are not in dispute. The level 2 conclusion depends on that record, and that is what is in question here. What is in question is whether those principles were applied consistently, and whether the record before you can be relied upon to support that conclusion. In this record, they were not applied consistently. My participation was conditioned, my access was inconsistent, and when those inconsistencies became clear, the record was not directly corrected. PIR number 6 for 2026 for the parent-teacher conference that occurred on October 24th, the day after my son was assaulted, is a perfect example that separate parent-teacher conferences is not acceptable. Because to this day, I still have no documentation from that parent-teacher conference that my ex was privy to. And importantly, the record you were given was not complete at the outset, and even now, it separates the district's conclusions from the counterpoints that they directly respond to them. That matters, because this is not just about what happened. It is about whether the record itself is reliable. And when the district's positions have been tested against objective records and legal standards, they have not held. Those positions cannot all be true at the same time, so the issue before you is not disagreement. It is whether a conclusion can stand on the incomplete and structurally imbalanced record that places the board in a clear position. Either affirm a record that is incomplete by their own admission and undermines neutrality, or require the district to complete the record so that its conclusions can be evaluated on a reliable and neutral foundation.
Thank you, Mr. Hudson. I'm going to have to stop you there. Thank you.
Thank you.
Administration?
Thank you. We have a lot in common with Mr. Hudson. We both respect and uphold his rights as a joint managing conservator. We both want the best education for his children. We simply disagree on some of the nuances of what his rights as a joint managing conservator afford him. We can sense Mr. Hudson's frustration with the communication between him and the other joint managing conservator for his children, but his due process for that concern is a matter for the family court and not for the school district. We ask the board committee to uphold the level 2 decision, and we stand committed to continue working with Mr. Hudson to support the education of his children. Thank you.
Thank you, Dr. O'Hare. Thank you. This concludes the appeal presentation involving the grievance filed by the parent. With respect to the grievance, the board panel may vote to grant the appeal, which means that we believe the complaint is valid and that the parent should be granted the relief requested. Alternatively, the board panel may vote to deny the level 3 grievance, which means that we believe the parent should be denied the relief requested of this board. As another alternative, we can vote to grant in part and or deny in part any of the level 3 complaint or requested remedies. Throughout the decision-making process, this board panel will consider only the complaint presentation and administrative response presented tonight at this meeting, as well as the documents in the record presented to us. We will return to open session to announce our decision. Prior to that time, I ask everyone to excuse us while we hold our discussion. Thank you. Just for the record, we left open to convene in closed session at 6:12 p.m. And now we are reconvening back in open session at 6:21 p.m. We are back on the record in open session, having returned from close at this time. I told you it was 6:21 p.m. Does any board member have a motion regarding the grievance presented by the parent?
I can make a motion. You know, I would just have a comment, I guess, that, you know, I applaud Mr. Hudson's willingness to be a part of his children's education. And, you know, I wish all of our parents, there's parental involvement in children's education. The statistics show that that's one of the most important things, and that's a determiner of success of that child in an educational framework. And so, you know, I applaud your wanting to be involved to the extent that you are. You know, I think at the end of the day, the way I look at this is we have a lot of joint conservators, whether they be married to each other or divorced, or maybe never married at all, or maybe grandparents or aunts and uncles. And so, in the spirit of applying the law evenly and giving everybody, you know, all the conservators or all the guardians for all 11,200 kids, keeping things equal, my motion would be to move to uphold the level 2 decision and all responses to the remedies sought by the parent.
Okay, we have a motion by Garrett Wilson. I'll second. Christy Schmidt, second. All in favor, say aye.
Aye.
All opposed, same sign. Thank you, Mr. Wilson. All right, if there's no further comment, then we can entertain a motion to adjourn.
So moved.
Second. All in favor?
Aye.
Move to adjourn at 6:23 p.m. Thank you all for coming.